Okay, let's get right at it. Let's bring in former Deputy Assistant Attorney General Tom Dupree and former DOJ Attorney Hans von Spakovsky. Gentlemen, thank you so much for joining us tonight. First to you, Tom. It got really heated in the closing arguments today to disqualify Fulton County DA Fani Willis from the Georgia 2020 case due to misconduct charges. Tom, where do you think it leads?
Well, Liz, today was an explosive ending to what has been an explosive proceeding. The testimony that we heard, the evidence that we saw was stunning. I think what's going to happen next is the judge said today he wants to take everything under advisement. That's judge speak for he wants to look back over the evidence, look back over the testimony, and figure out what the law requires. He's going to render a decision in about 2 weeks. My hunch is he was probably very disturbed about a lot of the testimony he heard, both from Fani Willis, from Mr. Wade, and from the other witnesses, because so much of what they said during that hearing, Liz, didn't seem to hold up under cross-examination and when they were shown the actual evidence, including the phone records in this case.
Yeah, so when they were shown actual evidence, they couldn't answer to it, Hans, and instead they're claiming racism. I mean, the allegation is she covered up and perjured herself, denying she hired her boyfriend, Nathan Wade, to work on the case, the Georgia 2020 case, gave him a big salary. He then bought themselves luxury trips. Fani Willis showed up for the closing arguments. What do you expect is going to happen, Hans? Do you think she's going to get removed?
Oh, I think the judge has no choice in it. If he doesn't do that, I mean, that would, to me, amount to judicial malpractice. Folks need to remember, yeah, a lot of focus on the adulterous relationship she's had with Wade, but there's at least half a dozen ethical violations and possible violations of state and federal law. Several of them didn't actually get mentioned in the hearing. Why? Because the judge said ahead of time he had enough evidence on those already. So I just don't think, and particularly, look, judges look at your body language when you are a witness in court. And Fani Willis, Nathan Wade, they all came across as evasive, not wanting to answer questions, and I think actually their appearances gave them a huge loss of credibility.
Yeah, so what Hans just said, Tom, you know, Fani Willis's lawyer downplaying this is all, quote, conjecture, speculation, saying there was no conflict. The defense team is saying there was half a dozen examples that she could have. He also said, the lawyer for Fani Willis reportedly said she could have financially benefited from stretching out this very complex RICO case. Let's take a listen to some of the closing arguments. Watch this.
Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need to go.
The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. You know, I don't even think love-struck teenagers communicate that much.
So you heard that, Tom. Your reaction, what matters more, lying under oath or the conflict of interest, or both? What do you think, Tom?
That's a toss-up in my book, Liz. Prosecutors shouldn't be coming anywhere near either of those two things. And look, what's going on here, to my mind, is very simple. The standard that prosecutors often use to describe their own conduct, the conduct of judges and other participants in the legal system, is the appearance of impropriety. In other words, you don't actually have to prove impropriety. You don't have to actually prove a conflict of interest. You don't actually have to prove perjury. It's a much higher standard. It basically says if there are facts and circumstances that create the appearance of impropriety, that it makes it look like something's not quite on the up and up, well, then you need to step aside and bring in a new team. And I think that's where the judge may go in this case.
Yeah, good head there. You know, Hans, let's listen to Terrence Bradley, picking up on what Tom just said. Terrence Bradley, an associate of Fani Willis and Nathan Wade, you're going to hear him mutter the words, "oh, dang," when confronted with his own text messages showing their affair started in 2021, not 2022, as they testified to. Bradley had repeatedly also denied any knowledge of their relationship numerous times. Listen to this. Watch.
Do you think it started before she hired him? You see that?
What do you say, Hans?
Listen, his trying to back away from what he said in all those texts, those are prior inconsistent statements, and they bring up the classic adage the lawyer will ask, well, were you lying then or were you lying now? And I just don't think there's any way the judge is going to believe what he was trying to say in the courtroom now when you have all of those texts in which he was giving lots and lots of details about what happened. Plus, look, something that didn't get mentioned. Remember, he was the divorce lawyer for Nathan Wade. Adultery is a reason for divorce, and it can affect the division of marital property. He would be an incompetent lawyer if he had not gotten full details from Nathan Wade about his adulterous relationship so he could be prepared to deal with that in the divorce case.
Interesting. So there was a second Trump case that is hitting the headlines today. Both former President Trump and special counsel Jack Smith in court in Florida. No ruling yet on when it will start from Judge Eileen Cannon, Tom. Special counsel Jack Smith wants a July 8th date for the federal classified document case. That's a week before the RNC convention, Tom. The Trump team asked for August 12th. What happens?
My guess is she's going to go with the Trump team's proposal, Liz. I think August is a more sensible trial date under the circumstances. As the judge has noted, this is a case that's going to require the parties to go through boatloads of classified information. And that's the sort of thing that always takes far, far longer than you anticipate. That said, look, I think that this judge and all the judges who are handling these Trump cases are going to have a real challenge managing all these cases so as not to interfere even more than they already are with the campaign season. But it's like getting planes on a runway. You know, you got to sequence, you got to stage, you got to put it in an order.
You know, so what's really interesting too, picking up what Tom just said, Hans, the Justice Department's 60-day rule came up. It's an unspoken rule. Policy that federal prosecutors will not take any overt action against a candidate 60 days before an election. Jack Smith's team said they won't violate that, but how can they say that now? There could be delays because, you know, co-defendant Walt Nada's attorney is talking September 9th as the absolute earliest this starts. That's in violation of the 60-day rule.
Well, yeah, but it's not just that. You know, there's a federal prosecutor's handbook for dealing with election offenses, and it makes it very clear that federal prosecutors are not supposed to take actions which interfere in elections, particularly election outcomes. Yet Jack Smith waited, what, 2 years? 2 years to actually file these indictments, long after he had the evidence needed for that, and frankly, right as the campaign season for 24 was starting. So his denials that he's not trying to interfere with the election, I just think they fall flat.
Yeah, same with the Georgia 2020 case. They waited years to file that too. Let's listen and get your reaction, Tom, to CNN's Ellie Honig on the classified document case going to trial in July or August. Watch this.
It tells me, first of all, that Jack Smith has now concluded that it's very unlikely he's going to get his January 6th trial in. We just saw the Supreme Court take that case yesterday. I think he's done the math and seen that that's essentially a done deal in terms of trying it before the election. This would allow Jack Smith to at least try the Mar-a-Lago case before the election. And from Trump's team perspective, they get the win of moving the January 6th trial till after the election. If you're Donald Trump, you're going to have half that jury is going to be Trump supporters, Trump voters. So
there's also questions about the judge that have been.
The judge has been good for Trump. So I think if you're Trump's lawyers, and we've had reporting on this, you're feeling pretty good about your chances in Florida.
Tom, you know, the Supreme Court is taking up the presidential immunity claim from former President Trump in the January 6th case. Won't that affect the classified documents case too?
Well, it could indirectly. I think the biggest consequence of the Supreme Court's decision is that it's going to delay the January 6th trial in Washington by several months at a minimum. That does give the Florida court at least the opportunity, the judge can, and if she wants to hold her trial before the January 6th trial. But look, I agree. I think it's frankly going to be very difficult for the federal government to get either prosecution off the ground and completed before the election. They started this case very late, and they are now in a position of their own making where they've got to compress everything into a matter of months before November.
Interesting what Tom just said. You know, there's this issue too, Hans. People are talking about this as an injustice, the classified documents case against Trump. President Biden kept hundreds of pages of U.S. secrets in unsecured boxes, for example, near a dog bed, in his garage, possibly dating back to the 70s when he was a senator. Under the law, he had no right to take them as either senator or vice president. But special counsel Robert Hur said he can't put Biden on trial because the jury would see Biden as an elderly man with cognitive issues and, quote, diminished faculties. A lot of people out there are saying this is unfair.
Well, in fact, I think Trump's lawyers brought that up today as selective prosecution, and Jack Smith's lawyers try to say, well, it's not the same thing. But it is the same thing. Willful retention of classified documents. That's exactly what Trump is being criminally prosecuted for, and that's what Hur found that Joe Biden did.
Yeah, and Tom Dupree, final word. Didn't the Justice Department allow Biden's own team of attorneys to search and aides to search for the classified documents?
Yeah, they were remarkably accommodating, in my judgment, to allowing him to do that, to allow his own team to go in and conduct that initial search. My guess, and it's a strong hunch, is they would not have given the same treatment to former President Trump. Got
it. Tom Dupree, Hans von Spakovsky, you guys are so smart, so terrific. We really appreciate you helping us out this Friday night. Have a good weekend, gentlemen. You worked hard there. Thank you so much.